The facts of this case is where Schmidt, a consulting engineer, assisted in obtaining a permit for an iron ore in Johor, where Tan promised Schmidt a tribute of 1% of the total sales of all of the iron ore produced and sold. In 1954, when the company was formed, an agreement was entered into by the company and Tan, which allowed the company to take over payment obligations to Schmidt, an agreement to which Schmidt was not to party.
Hi, Assalamualaikum. My name is Afika binti Wahab, and I would like to talk about the ruling of the cases Kepong Prospecting Ltd versus Schmidt 1968. The ruling of the cases is consideration. An agreement without a valid consideration is void unless they belong to one of those category of agreement listed in the same section as being exempted from the rule. So, consideration may be viewed as a sort of bargain or price which one party pays to buy the promise or act the other. When the promiser promises to do or to do abstain from doing something, the promise must pay price for it. As you guys know, this price to be paid may be an act or abstinence, or a price to perform a future act or abstinence.
Hi, Assalamualaikum. My name is Wana Anastasia binti Mekam Razaman. So in this case, this being in consideration of the services rendered by the consulting engineer for and on behalf of the company prior to its formation, after incorporation and for future services. So the services rendered after the incorporation but before the agreement is clearly a past consideration. So the Privy Council ruled that it did constitute a valid consideration so that Schmidt was entitled to his claim on the amount.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iqmal Ali bin Mafali. I will talk about application of law. The court held that the consideration by Smith after the incorporation of company but before the agreement was made was a valuable consideration and could be claimed under the law. Smith, however, could not claim on the consideration before the incorporation. This can refer to illustration C, section 20C of the Contract Act 1950.
Assalamualaikum and salam sejahtera. My name is Muhammad Fakhruddin bin Muhammad Fazil. Today I would like to present about application of law for case Kepong Prospecting with Smith 1968 1 MLJ 170. Alright, for the application of law, there was not a scrap of evidence on oaths that the respondent had a cause of action at all, or that the appellant company had handed over a great deal of their property or money over to others, or that they had altered their course of business with intent to obstruct or delay any judgment the respondent might